Good afternoon, evening, whenever you're watching this. Hello. Hope everybody is well. Not legal advice. Please like, subscribe, share. I think I have interesting information. I was going to talk about GTII. Of course, this is not legal advice. Please like, share, subscribe, comment, do backflips, whatever. I appreciate anybody who's watching, and I appreciate any comments, especially the nice ones. I like those especially. And JR is on vacation. He's taking a vacation. He sends his greetings, and we all wish him well. So I wanted to talk about GTII, and there's something that has developed since I was going to do this. This kind of usually works. So before I get into that, just a couple of quick things. How many telemarketers does it take to screw in a light bulb? One, but they always do it at your dinner time. How many therapists does it take to screw in a light bulb? One, but the light bulb has to really want to change itself. And last but not least, how many gorillas does it take to screw in a light bulb? One, but you go through a whole lot of light bulbs to get there. Anyway, those are all mine. I just created them out on the spot, just made them up. That's why they were so fantastic. Anyway, so originally I was going to do, so this is about GTII, and I've been following Alpine. Oh, I might as well update you on Alpine since I brought it up. So Alpine is in the Supreme Court. They are seeking a petition to have the court determine whether FINRA can exist. The FINRA and somebody else opposed it, basically, and one of the reasons I had raised, because it was premature, because they hadn't been kicked out yet, amongst other reasons. That was filed about a week ago, and we'll wait till the Supreme Court decides whether they're going to take the case or not. And if they don't, what I expect is Alpine, who's the prime broker for GTII, will then try to take up the other case, which was the expulsion that was affirmed most recently. And again, distinguished, there's an expedited expulsion. That's what's before the Supreme Court. Separate and apart from that, they got expelled by FINRA, and that was affirmed by their appellate section. And that's the irregular expulsion. That is on appeal to the SEC, and I'm wondering if they're going to wait to get the appeal heard by the SEC before they appeal to the Supreme Court, or they're going to do it before the appeal. They have 90 days to do it. I think we're about 30 days in, so it'll be interesting to see what happens. So that's the current update about Alpine and the Supreme Court. I mentioned they were doing some work for some company. I think it's called Vocadia, or Vocoda, something like that. I have no idea what they're doing, but they are. And that's Alpine. So that's the side stuff. So now we're talking about GTII. And first, I kind of want to lay a kind of a foundation for whatever I'm going to say. I note that if I post or put something on X and I'm bitching about something, that people always determine, therefore, that there's nefarious conduct going on. That, in other words, there's wrongdoing that's going on. And I don't intend that idea to be communicated. It may be more that I think things should be sped up, or maybe we differ on strategy or something like that. Unless I tell you that somebody's a scumbag or a crook or whatever, I'm not signifying that I'm suggesting any nefarious conduct. And I see, for example, so like, when it comes up, I'm bitching about the speed of things. And I see on X, people are posting things that go way beyond that, and then draw conclusions about the receiver or whatever. That's not what I'm suggesting, and I don't think that's an appropriate consideration. Notwithstanding whatever concerns I have about speed, etc., the receiver is diligently doing his job as he thinks fit, and that's the way I see it. So I have issues, but it doesn't go to me being concerned about the legitimacy or the intentions of the receiver. It's usually, again, just speed, difference in strategies, etc. So if somebody's, when they if somebody's taking a comment or an idea I express and interpreting it that way, that's not what I intended. So that's clear. Okay. So now we're talking about GTII. So now I'm shifting from that. So I've been bitching about GTII and the speed of things and my hope that it would accelerate. And I had heard, and I kind of done, either have done postings or done actually videos, live streams suggesting that there were a couple motions that were in the pipeline. There were 4 things. A couple of motions in the pipeline. I was concerned about the audit, and I was wondering where the receiver's report was. I think the fourth, either the third or the fourth interim report. So bitching about that, and all kinds of things are said and requests are made, etc. And then I was told that apparently this was filed, but it took a little time to get calendared, and it got set up on the 27th. So what is this that I'm looking at? The document I'm looking at, and one of the motions that was filed is the receiver's motion to approve and set up a claim procedure. So it's basically this. So there may be claims that people have against GTII or against the officers and directors, independent of what we're doing in these lawsuits. And if they have those claims, this procedure sets up a process whereby there's an end date. So basically what happens is there is a motion that's filed that says anybody who has a claim, a real claim, can submit it to the receiver at the receiver's address, has to file a proof of claim, and then the receiver will make a decision, a determination, and there may be hearings, etc. after that. But that entire period of time to make the claim is 90 days from the time, at least as I read this, 90 days from the time the order is entered by the court. The hearing on the motion will be, I think, the end of May of this month. So the order would be, if the motion is granted, setting a claims procedure, then the hearing would be at the end of May. And if it's granted, then you're figuring 90 days from the end of May would be the end of the claim period if anybody didn't file a claim. And again, it has to be a valid claim, legally supportable, etc. Not legal advice, of course. But if somebody submits a claim after that, then it's deemed late, and I don't think the receiver would act upon it. If something's legitimate and submitted before that, then the receiver, I'm sure, and his counsel will consider it and make a decision, or there will be further hearings on it. So this motion sets that in process. And why is that so important? Because you couldn't go forward with a transaction with, for example, AIversity unless everybody knew that nobody could file in any new claims, because why would somebody want to take on a company and not know what claims or what possible exposure they have? So this motion is a motion that is favored also by AIversity. So AIversity agrees with this motion, as well as obviously I agree with the motion and the receiver agrees with the motion. And the hearing on this, again, it's scheduled May 27th, but there's a status conference hearing on May 28th. And it may be that this motion is heard on the next date. And again, I think it's a way of just clearing out the claims process so that any potential target can take on the company, knowing what the potential risks are and being able to move forward. Without this, it would be tougher to evaluate what the risks are, and it might be slower in acting, or something along those lines. So that's that. Before I talk about the second motion, what's interesting is it also refers to the receiver's report. So one of the items that I had mentioned that I wanted to know about or was waiting for was the receiver's report. And in the motion, the body of the motion, it references that the receiver's report will come out prior to the hearing in this particular motion. So since today is May 6th and the hearing date is the 28th, I'm speculating that sometime between today and the 28th, we will see the receiver's report, because that's what the motion says. And I don't think they would have represented that, the receiver's counsel and the receiver, unless they believe that was the case. So I'm expecting the receiver's report to be addressed before the 28th. And Of course, when the receiver's report comes out, I will talk about it as I'm talking about this motion. And I expect the receiver's report, or I'd be surprised if it didn't, will also discuss what the status is of the audit, when it'd be completed. It might also discuss, status of, now I'm speculating. So now I'm speculating at this point in time. They might discuss, if and when it's going to be tradable. I know I've heard some discussions about tradability, mid-year, but I don't know if that's realistic, but I've heard that discussion also. So we have the motions been filed as to the claim process. We have information that the receiver's report will be filed before May 28th. I expect it will also deal with the audit. And there's a second motion that I heard. I haven't had it confirmed by the receiver, but I have spoken to people that I think know about it, the contents. And the second motion, and I'll wait till it's filed because I don't want to give a heads up to anybody against whom it might apply and give them an opportunity to prepare. But the second motion also is a motion that I know is favored by AIversity as well as the filing party, and it'll relate more directly to the shares, and that's about as far as I will go. And I think it's again, I don't want to give any notice to the bad guys. It'll become obvious when it's filed. I haven't seen it, so I don't know specifically what the language is and how it's referenced. But again, I know it's going to be about the share issue itself. And I know also, or at least my understanding is that that process will be important also for the target company and will be important in terms of letting the transaction complete. And again, when the motion is filed, I think it'll be filed within a week. I was actually expecting it to be filed already. I think, and I'm speculating here, that the filing party, which is the attorneys for the receiver, wanted everything heard on the 28th. So it may be the case that this motion is filed in the next couple of days, and there's a procedure by which you can expedite the hearing date under special circumstances. And it might apply here, but I don't know. But when the motion comes out, I will clearly and specifically talk about it and delineate what's going on. So before today, just so we kind of put everything in proper context, the concerns I expressed were, what about these two motions? What about the receiver's report and the status of the audit? After I got this motion, and now I've received one of the motions, I've seen reference to the receiver's report and when it's coming out, and I'm speculating about the audit. I expect the other motion to be filed, probably within a week, speculating a little bit, but somewhere in a short time frame. And once the motion is filed, then I'll have an opportunity to go through it and explain it to you, probably even better than I just explained the claims motion. But both are necessary and important, I think, to everybody to go forward and to complete any future transaction, whether that happens or not. So those are the two, kind of the four things and the change that happen. When the motion is granted, there'll be a claim form, and if anybody has a claim, they certainly can assert it. I don't know how many claims that will be. I don't know how much money there will be to pay claims. I don't know what the standard will be, but when it happens, we will talk about it, and it probably will also be available, I presume, on the GTII site and certainly on the receiver site. And I would say, obviously you could ask the receiver for a claims form or ask him to post a claims form on his X account so everybody can have access to it. So that's kind of that part. Now there's kind of an interesting twist to this. And I've kind of thrown this out in the past. And I've spoken at length with our counsel. So in this case, it would be Plaintiffs Council. So now I'm referring to the Nevada lawsuit. So Nevada lawsuit, I was one of the plaintiffs. We are represented by Plaintiffs Council. Alex is the lead attendant. Alex and Chad are the lead attorneys. for us. The receiver is the receiver, and the receiver has his separate counsel. And then there's everybody else involved in the case, all the other parties. Most of them are represented. I, up to this point in time, have been represented by Alex and Chad. After a very friendly and productive discussion with those gents, Alex in particular, they agreed and we agreed that it would be a strategic advantage if I represented myself as one of the plaintiffs. So we've come to an agreement, and effective when the paperwork is submitted, from this point forward, I will be a plaintiff representing myself. And by the way, it has nothing to do with the work product of Alex, because I think they do a fantastic job and have done a fantastic job. Purely a strategic decision that we both think will help be in the interest of all shareholders and will help move this along. So the paperwork will be prepared and filed. Now, as opposed to having to go through counsel, I will be a party and I will be directly notified of everything and have more active role in participating. I'm not going to tell you I'm going to have a oversized role, but if you follow that in my videos, I'm not afraid to share my my thoughts and convictions. And in dealing off the social media, I can be much more direct and communicate that in a professional way. So that's what's going to happen. It will not stop me from doing these kind of reviews and interpretations of documents at all. I will continue to do that. Hopefully, we'll be able to do them even better than I have to this point in time, if they have been decent at all. But I will be able to improve to the extent I have more direct communication with all counsel. So our kind of interchange and how I'm presenting this will not change. If, however, you're one of the plaintiffs, and Alex wanted me to tell this, so I'm referencing it because he knew I was going to, he understood I was doing a live stream, and I told him I was going to talk about it, and he just wanted me to remind you, to the extent that anybody, there's about 200 plaintiffs. Obviously, you can interact with me and ask comments, and I'll answer like I've done to this point in time. But to the extent you have questions that you want to ask counsel, Alex and Chad, and you want a different interpretation or something, he said, feel free to reach out and to contact them. So now you have, as opposed to one, you have two. I'm available again to the extent you have questions, comments. I will try to ask them directly. What kind of claim, somebody asked? Perhaps if you got had an agreement to get something, I'm making it up, but let's say you had an agreement with GTII and GTII promised to give you a car, and you paid them $40,000 and they didn't give you the car. That would be a claim. So, those kind of claims relating to claims against the company where they didn't perform, I probably amounts to claims against the officers and directors directly, those kind of claims. But I can't give you legal advice on that. But generally, that's kind of the way I see it. And I think it's phrased, it's claims against the company or against the officers and directors. And then you'd have to prepare the claim form. And again, I would suggest, and I'll probably ask also directly, you're going to have to submit a claim form. To the extent you have a claim, you submit the claim form to the receiver. The receiver then will do his process, and they will evaluate the claims. There'll be then some hearings or process in which to have some interaction and adjudication of those claims. What the claims are, I don't know, because I don't know what everybody's potential exposure is. But again, the example I gave is, you had a direct contract with the company and they didn't perform. That would be a claim. That would be kind of a claim you could assert. So everybody might have their own. I don't know what everybody's business relationship was with them. So, but I wanted to answer that question. All right. Hopefully it does answer that question. So getting back to where we stand in terms of legal representation. So everybody who is of the 200 plaintiffs or so plaintiffs, other than myself, are still represented by the same people. You have the option now to contact them directly and ask questions. And obviously you can direct them at me, and I'm happy to answer questions also. I think, again, it will provide, and that's why I had suggested it in the past, I think it will provide a strategic advantage to us in pressing this forward. I look forward to working in a very amicable way with the receiver as counsel, obviously with Alex and any of the other attorneys. But again, I think it's strategically advantage if I'm directly involved otherwise. So that happened today, by the way. That was finalized today. So that's why it wasn't referenced in the video or in the title. But I think it's a significant thing, and it'll give me a different insight. And obviously, an attorney this is not foreign to me. I'll be able to interpret what's going on, and should have a much more inside view of the legal aspects as they go on. And obviously, I will report on them, and my interests obviously don't change in terms of for the benefit of all shareholders who are impacted. So I will keep you apprised. So to summarize, so I had expressed concerns before about the speed and the filing of the two motions. I had expressed concern about not seeing a receiver's report and about the status of the audit. We got one of the motions filed with regard to filing claims. We got notice about the receiver's report will come out before the 28th. It's likely that the receiver's report will also reference the audit. And my expectation is the second motion that's relating to the shares will come out, although I haven't seen it, will be filed within a short time, probably this week. I also said that to the extent there's differences among strategy or speed, that does not equate to a claim of nefarious conduct. And to the extent that somebody portrays any comments where I'm bitching about the speed of thing, that I'm questioning the integrity of anybody, that's not the intention. The intention is to speed up and put pressure on. And to the extent somebody misportrays that in a way of trying to jolt your confidence in the cause, ignore it and move on. That's what I do. I ignore it. I try to ignore those people and move on because they're not in their interests are not aligned with ours. And last but not least, summarizing, as of today, although the paperwork is not finished, per agreement and perfectly amicable agreement, strategic arrangement, I will be representing myself in pro se from this point forward in our action, and will be acting as such. I'll continue to do these videos, and I will report precisely what is going on to the extent I know. And you have the option to kind of still reach out to me, which I hope you continue to do so, obviously, since I'm the only one I think is basically doing these videos at this point in time. But you're also, if you're one of the plaintiffs, feel free to reach out to Alex and interact with them. So I think that summarizes the points. Kind of interesting, good progress with the motion being filed, good progress that we know that the receiver's report, probably reflecting the audit, will be coming very shortly. Second motion also, I think a strategic advantage about my participation directly as an attorney. And last but not least, ignore the nonsensical black noise out there, as I referenced. And to all of you out there, be well, take care. As soon as I am officially in as counsel, I'll let you know, because it requires some bit of paperwork that has to be filed with the court. And again, I look forward to being able to kind of keep everybody updated as to what's going on. And that's about it. So everybody be well, take care. If you have comments, questions, put them in somewhere, and take care and be well.